Okay, let's go ahead and start. And as people come in, they can choose to review the full presentation. We'll have it up on the website. So let me move over here. So Association for the Chronically Mentally Ill would like to present HIPAA. Lose the handcuffs, get the facts, and learn how to use them. So Holly Giesel, who is a founding board member, is going to share her wisdom on the topic. We do have a request that as you go along, please try and indicate what are national insights versus what are Arizona insights. And this is someone that's joining us from Pennsylvania. So let's go ahead and begin. I'm going to probably turn my video off so I don't lose bandwidth because I'm not at home, so I have bandwidth. But let's go ahead and start. Let me know when you want me to move the slides.
Okay. Well, good afternoon, everybody, on this sort of hot July day all over the country. It's a pleasure to join you via Zoom. We've all gotten accustomed to Zoom in the last few months, I think, more than we ever envisioned. Let's go, first of all, to start with a point that was questioned: what is national and what is Arizona specific? 90%, 95% of the content of this is going to be federal. I do have some Arizona specific slides, and those will be apparent, but we'll talk about the intersection between federal law and state law a bit. And so I think that section will be, is generic enough that it will be applicable to whatever state you're viewing and participating from. Okay, let's go to the beginning, as we say. Of course, there are the obligatory disclaimers about our presentation tonight. Starting with what we are not doing. We are not giving legal advice. This is my views on the HIPAA rule, what it does, how it affects you. But it's not the advice that you would expect if you went to an attorney. If you have a specific question, you should do that, of course. This presentation also is not representative of the views of ACME's board or individual board members of ACME. Who's the target population? Next thing I think that we need to clarify. I'm going to be talking about adults living with mental illness, including substance abuse, and their family and friends. This is not a presentation tailored to minors, children. So there is overlap, but there are some special circumstances that have to do with children. And we can do that if there is sufficient interest. We can certainly do a HIPAA presentation on children and parent and family rights under HIPAA as related to children. Third, what's the purpose of this? Well, I view the purpose as to enhance advocacy for continuity of care with accurate information about how to get access to records and information about HIPAA's privacy rule. So as Laurie mentioned in the beginning, the purpose of this is to try and help you find the key to unlock handcuffs that may be affecting your ability as an individual living with mental illness, or an advocate, or a friend, or a family of someone who is. So the purpose is to get some information, a framework for looking at things relative to HIPAA, and enabling us all to be better advocates for better care. That's what ACME's about, and that's what this presentation is about. Next. We're going to talk about three broad topics that I think are important in order to get our arms around this big conversation that falls under HIPAA. The first is We're going to talk about the privacy rule, which is the rule that most directly affects us when we're trying to get information or give information, if we are the patient or we're a family or friend. So we're going to talk about the privacy rule and a little bit about how that privacy rule has evolved within the HIPAA quote unquote industry. And there's a huge industry out there, as we'll talk about, that sort of runs HIPAA in some ways different than I think our Congress intended when the legislation passed back in 1996. You need this context in order to be able to know where you've got leverage and where your levers are to unlock those handcuffs. We're going to focus on the privacy rule again and accessing information. Specifically, I thought it would be fun to do what I've called a HIPAA IQ test. So we're going to do true-false questions about HIPAA, and there are indeed some trick questions. And then I'd like to spend a bit of time as sort of a challenge talking about the future. How do we use and maybe modify HIPAA to promote better recovery, better care continuity, and how do we envision life without the handcuffs of HIPAA in Arizona? I think a lot of what we'll talk about here is applicable in other states. I put this under future because I firmly believe that individuals like all of those on the call and committed advocates in groups around the country can change public policy. And so to the extent that we identify these handcuffs that we live with HIPAA, let's change it. Let's figure out how to make the rule better. And we've seen in the past few years, I'm not saying because of this administration, this is a completely apolitical comment. We have seen some improvements and some changes in the guidances that come from the Department of Health and Human Services about HIPAA. And I think that's important to always leave a presentation with a positive agenda of how we can go out and change things. Okay, let's proceed. So HIPAA is, as I think most listeners know, it is much more than a privacy rule. Although the privacy rule, in my opinion, is what most of us live under and struggle under, and that's where those handcuffs are. There are 5 primary HIPAA rules. First of all, the privacy rule that defines and governs the disclosure of personal health information. I like this diagram because it puts that, what I call, above the line. Below the line are the security rule, which has to do with all your e-PHI, your e-personal health information. The omnibus rule, which was a huge piece of federal legislation that passed a few years back and put these new high-tech rules that govern data transmission into HIPAA. Then, of course, we have the enforcement rule, which governs how investigations of alleged HIPAA violations and breaches are enforced. And then we have the breach notification rule, which has a very short timetable, for the most part, of 60 days. If you have a breach that's reportable, not all breaches are, that you have to report. I think it's important to understand the breadth and the scope of what HIPAA became after the privacy rule was first introduced in 1996. Let's go to the next. I'll also say, just as an aside, much of my work as a lawyer in the past had to do with breach notifications involving anywhere from a 3-person practice to a 50-person practice, with penalties ranging from nothing to multi-million dollars. So I spent a lot of time below the line as an administrative lawyer and a litigator, but my real love, my real joy in HIPAA, and I do have a lot of interest in it, is how we make the things above the line better for health policy. So let's go forward.
So Holly, we have one question.
Sure.
Was there ever the intention or the background that um, they put that the HIPAA laws came to be because the desire to share personal health information with the intention of making it easier for healthcare providers to see health records, and this was the insurance that no one was going to abuse that information?
That is absolutely correct. Back in 1996, the evolution of electronic medical records was clearly in the front of people's thinking at the policy level. We didn't have an EMR then, but everybody was thinking about it. Second, you'll remember that was the height of the beginning of managed care. I think Len Tamsky may be on the call, but our managed care work really goes back to the early 90s, and by 96, this was booming. So there was a real desire, and I think a critical public policy point, that we needed to create a more streamlined, coordinated way to govern retention, retrieval, disclosure, sharing of medical information across providers, because remember, managed care were networks of providers, and we needed to do that in a way that was secure and would lay the foundation and the groundwork for big data and huge records that could be shared nationally or internationally via our electronic medical records. So that's an excellent question, and it's a part of that context that I talked about in the second slide that I'm really glad the viewer brought up. Thank you. So how did we get to everything below? What do we have now as a result of those rules? And this is what how I see the evolution of HIPAA from the very policy-oriented discussion that the prior question raised. As HIPAA evolved, in my view, it incentivized providers to focus on internal compliance to prevent breaches and fines, not on assuring access to information to support recovery in the behavioral health industry or to support those managed care patient outcomes and goals in a general medical managed care network. So you have now, if you look on the right, we have a situation where you have so much emphasis first on technical protections, the security rule, the physical protections, again, the security rule, all the administrative protections that have to be in place with training and all the things that hospitals have to do to comply with the high-tech rule, the security rule, and all the issues that we talked about, the breach rule. You then get down to the HIPAA privacy rule, and it's right in the middle, but it's only one line, one little box out of 6. Then we go to breach notification and the omnibus rule. So you see, when a provider today, particularly, and then we have part 2, which deals with substance abuse. So when you look at what providers are forced to focus on, it's very easy to understand that a lot of their focus is not on the privacy rule, and there are few incentives to focus on making interaction with patients as smooth and careful and responsive as there are incentives to address the technical issues and the physical protections. Let's go ahead to the next slides. And so as I see HIPAA evolving, HIPAA is driven by penalties, not incentives. So you have a breach, and you don't do your annual training, you don't do a risk assessment, and it's just like a PK in soccer. You get a chance, the government gets to come in and kick the ball through the goal, and you lose points, you lose money. There are no blue ribbons for compliance, for being responsive, for having a record for meeting all of your patient records requests, and the requests by family and friends, and having physicians, social workers, psychiatrists, nurse practitioners, PAs, all your staff being responsive and caring about whether they have met the patient's information requests. So we go to the next slide.
One thing, Holly, another question that comes top of mind. When you talk about sharing information, it brings up, if you can just imagine back probably in the days where doctors and hospitals had patient charts, some providers may have had one box that said name, and others may have had 3 boxes that said first name, middle initial, last name. So I wonder, and I imagine if part of the initial infrastructure was settling on what form and what template so you could map, because you don't want to map a middle name to a first name or a last name to a first name. So I wonder how much they spent in that pre-setup.
Well, there is a standard coding set. There's standard data sets now that are part of the various rules. A lot of progress was made. But Laura, your point is an excellent one in this regard. The major electronic medical record systems that have been developed and laid on as a way to implement and have a HIPAA compliant data sharing system around the country don't talk to each other. So Cerna doesn't talk to this, doesn't talk to that. So it's really, and my daughter was here earlier, as you know, helping me with the slide. Her, as a public health scientist, her research is in building platform to incorporate, she trained at Hopkins where everything is big data. Her research, in fact, and her expertise is in building platforms that can make all these different records talk to each other in a HIPAA compliant way that takes clinical information from a variety of sources. So as an engineer, you're exactly right. The way this evolved, piecemeal in the industry that developed, because we are a private sector capitalist society, right? All those good things. I'm not criticizing that. Apolitically, I say that. But it evolved with everybody going out and making a better widget, but the widgets don't all fit together when you try to build a building with them. And so, and it is a system with heavy government regulation, driven by penalties and not incentives. I spoke to an assistant general counsel at Department of Justice recently, and we were talking about this, about the fact that HIPAA only penalizes providers. There's no way that you report 100% compliance or 90% compliance with meeting your patient's records request timely. So you get penalized if you have a breach, and you get nothing if you have wonderful rapport and you figure out how to share all of the information with patients and families so that you really have good information across the continuum of care. There's nothing to reward you for that. So in my view, the incentives are misaligned, and that's something I'd love to see changed. So
we
let's
have
go next.
we have a question. So it seems like the providers are punished by the federal government, but the parents and patients and family members and advocates are punished from the HIPAA interpretation. And the question is, or statement is, well, why is it so difficult to get information, talk to people when you have guardianship?
Well, it shouldn't be. HIPAA defers to state law. HIPAA uses the term personal representative. And by statute, HIPAA defers to state law, incorporates the state law definition of who is the responsible decision maker under state law, whether it's a guardian or somebody with a power of attorney or a parent, and in terms of surrogate decision makers, what the state law provides as who has the authority to make that rule. So why is it difficult? Because the emphasis has not been from the federal government to providers to incentivize them to really train the employees at the level we're all dealing with when we're trying to get our medical records, or get information. We get the response, I can't do that. HIPAA won't let me do that. The people who are interacting with us are not the people who've been trained or have the authority to use judgment and give it to us. So the way HIPAA has evolved in terms of regulation penalizes everybody for the very reason that Lori, that the questioner mentions. Let's go to the next slide. So the real problem, as we're all seeing, is that the focus on HIPAA is technology, not people. It's, do you have compliant phone systems? Do you have a compliant email system? Do you have the right data, that the approvals and so forth? It's all on the compliance with the security and the data side of HIPAA. Very little focus on the way that we use medical records to communicate important information across care teams, across different providers, and with the patient and their loved ones, their guardians, their family members. So the incentives are misaligned, in my view, and the focus, as HIPAA has developed within the industry that's making gazillion dollars off of HIPAA compliance, are driving a focus that is not patient focused. It is regulation focused and compliance focused, with no rewards for, no blue ribbons for working with your patients productively. So let's go. So this is a great, I'm so glad we're getting these questions. So you all see all these little emblems around, and you may be asking, well, what does it take to become HIPAA certified? If you have a computer program that you're selling, if you have a data retrieval program, you may have walked into a clinic that says, has the compliancy group, which I love, I use their materials, HIPAA seal of compliance, HIPAA verified. So what do you think it takes to become HIPAA certified?
A fee?
Well, you're close. You're close. Remember, there is the industry, the HIPAA industry. So let's go to the next slide.
Okay.
And the answer is, buy a commercial compliance program that sells you a badge. There is no government accreditation or certification process. You go pay the compliancy group, which I used to do, a lot of money, fair amount of money. Their forms are excellent. Their checklist is excellent. They have a whole risk assessment. They have annual training guides. And you get a HIPAA seal of compliance, and you can slap that baby on your front door or your car bumper or wherever you want to put it. So there is no such thing. At the end of this, I thought about, maybe I'll take it to the ACME board. Since we've done this webinar, we'll do up a little badge and provide it to everybody who enrolled and say, ACME seal of approval, HIPAA knowledgeable. And so, you can say, well, okay, I'm HIPAA knowledgeable per ACME.
So the takeaway, Holly, from that is that don't be fooled if you see a HIPAA verified or seal of approval, that they know what they're saying.
Not.
Okay.
Now, as an attorney, however, if I'm working with providers, one of the things that you would do if you're risk management oriented and you don't want to get in trouble, you want to say, oh, we did our due diligence, we were careful. You go and you sign up with the compliancy group or some other good group. You do their program and you say, look, we did this program. It was done with a third party. We didn't just do it internally. And they said we did it right and we passed. Here's our seal of approval. So to that extent, it's industry driven, it's risk management driven. Again, nothing in these programs, these commercial products that you buy, is going to have any emphasis on doing things right. It's going, or helpful. It's going to tell you what you can't do. Compliance is all about what you don't do in order to stay out of trouble. It's not about what you do to help your patients and other care teams with which you are, or guardians, parents, and so forth. So what's interesting to me is I just did some quick checks this morning, and I have always believed that access to medical record information was essential if you want to have people engaged in their care and participating and becoming empowered and developing self-efficacy and becoming resilient, really. There is pretty good information, not related to behavioral health, that access to medical record information may be helpful. 8 in 10 people who look at their medical records online found the information was useful. A little over a fourth, however, are unaware of the fact that you've got a right to an electronic copy of your record. And amazingly, 41% of Americans had never seen their health information that's on file with their regular doctors. That's, by the way, from the healthit.gov site. It's good. It's an interesting site to look at. Now, by the same token, this is a physician in town who when we've had these conversations about getting more access to information for friends, for family, for not guardians. Guardians have an absolute right to information from the same as the individual does. We all have to acknowledge, I think, that not all of our friends and our families are healthy, right? Mm-hmm. And so there's a huge potential for misuse and harm to the patient. However, and back to what I talked about earlier, there is a growing recognition including at the federal level, in the Department of Health and Human Services, in SAMHSA, that mental health professionals can better prevent harm if they are able to have better information sharing. HIPAA can help mental health professionals prevent harm if it is implemented and better oriented to promoting discussion and disclosure in the appropriate circumstances. Okay.
So we have 2 questions, Holly. The first one is from someone that said they'd never want to be restricted from access to their 18-year-old. What do they need to do to when their kids are teens and kids heading to college before they turn 18?
Sure. Everybody, before your child goes to college, you should have the appropriate documents in your state and or the state where the child is going to college that will enable you to have access to all the medical records, his or her medical records, including behavioral health records, and to make healthcare decisions for your adult child. So in Arizona, you would want a durable medical power of attorney. You would want maybe a financial power of attorney that allows you to do to make decisions about that. And you would want, when your child is there, you want, and almost all universities that I have seen have a standard form for student health, the student health service. You want a signed authorization for access to medical records, and if they have a form for release of information, you want that form signed as well. Release of information is not a HIPAA designated form, only an authorization is. But those are the forms that I had when our kids, 4 of them, went to college, 2 out of state and 2 in state. So you want those forms. So absolutely those forms. Next.
So, I mean, but it seems a little ironic, and I've heard this before, that even if they won't talk to you, they will call you if you're the one that has insurance to pay the bill. But even yes. Even asking you to pay the bill, isn't that like opening the barn door and letting the horse out? I mean, if you know that your child, let's say, went to a Planned Parenthood or went to something else, the nature of the call itself is giving some information, right?
Yes, you do not have to have an authorization. A provider doesn't have to have an authorization to contact the payer of the bill. So yes, there is that. There is that dilemma, and we'll talk about what is in a HIPAA authorization, what it has to contain a little bit later. But one of the other thing to understand is that your adult child can revoke that authorization at any point.
Mm.
So if you've gotten an authorization signed and it says it expires, 1 year from today, or on a date certain when he graduates from the university where let's say the student health service is, that is authorization is good only as long as the adult child doesn't go in and revoke it and say, no, I'm revoking that.
Now we have another question related to that. Or statement. It's important to state in the release of information the end date when they're going to be completing college. Don't do it year by year. So can you make a multi-year? My somewhat adult child is going off to college for the next 5 years.
Sure.
I would like access to information and have them sign it.
Some people would hope they finish in 5, but even that's not always the case, right?
Yeah.
You can, although remember, HIPAA sets a requirement. Anything that providers want to do, institutions want to do, that is more stringent than that requirement, they can do it. You can't do less than what HIPAA requires. You can't not have an authorization. But a school or a hospital or a provider can certainly require that they won't accept authorizations with more than a 1-year expiration or 2-year expiration. There are some contracted prison healthcare providers who tried to do 3-month limits, and that was deemed not acceptable. But until somebody challenges it, they may. So I think you are entitled to fill out the form, the authorization, in whatever way you want it. The institution may have a pre-printed form that says it must be renewed annually, or won't accept it for more than 12 months or 15 months. And an competent adult can always revoke it.
So on the last slide or two, you said that everyone's entitled to their medical records. And the question is it true that a doctor can refuse to give full patient record to the patient? My family member made a request and was only given discharge summary, but not medical records as requested. And another person chimed in, one facility refuses to release medical records until after the patient is discharged. Is that legal?
Okay. Well, HIPAA is going to be silent on HIPAA doesn't address it in terms of what the provider must give you, but here's the answer to those two questions. You are entitled to all of your medical records except therapy notes, psychotherapy notes, which are kept separate from the medical record. Now, if your therapist puts those therapy notes in your regular medical record, then you're entitled to them. If they don't maintain them separately from your medical record, and generally that's the way they are done, so you're not entitled to psychotherapy notes because those are viewed as almost a work product of the therapist. The therapist is recording their thoughts, their interpretations, their views. So it's different than the other parts of the medical record, which will be progress notes, which will be signs, symptoms, x-rays, testing results, and so forth. So you're not entitled to psychotherapy notes. You also are not entitled to information which a provider may deem may be harmful to you, is not in your best interest to have. That's often the case. We see that in psychiatric notes. Now, that may be the case for you, but if you give an attorney or your guardian goes to get those records, there is no part of that medical record under Arizona law, and there's no provision in HIPAA that it not be provided to someone to whom you have given a legal authorization. I've had many providers try to pull that and say, we can't give you this because it may we deem it to be potentially dangerous, harmful, not in the patient's best interest. And I say, well, that's fine, but I have a valid authorization, so let me have it. And we get it. So I did not quote the exact language there. And I can give you the exact language that the HIPAA uses and that Arizona law uses. But it generally is that the provider doesn't use it may be dangerous or harmful and not in the patient's interest to give them that record. I see that a lot in psychiatric hospitals, in particular one here in Phoenix, where records are often withheld. They don't give them to you. You go back and you ask for them, and it's because staff have written really foolish and snide, hateful comments about a patient in the record. Well, that's their problem. It's certainly not very professional, and it's not helpful to the treatment plan. But when they realize it's in there, they try to withhold it on that basis.
And I think one or comment providers often say they aren't allowed to repeat information that relatives have supplied. Is that at all true? So
I'm sorry, that they're not allowed to do what?
Repeat information that relatives have supplied.
I don't know what that means.
So
you're entitled to your medical record.
So if the family says, our loved one did X, burned down a barn, killed the animals, whatever, right? And then that's in your medical records for that inpatient stay or that treatment. What I think they're saying is that providers often say they're not allowed to repeat information that relatives have supplied to the provider. Is that true?
Yes, there is a provision in HIPAA that a provider may not disclose information that, if disclosed to the third party, could result in be harmful to the patient or to other third parties. And the reason for that is the provider, if a sister tells the psychiatrist that my brother told me that he burned down the barn and there were 3 people in it and they perished. Mm-hmm. If I had that in a medical record that is produced and falls into the hands of police, could be harmful. Now, will the police get it with a subpoena? Well, hopefully not, because you don't respond to subpoenas. You get a court order or a warrant. Subpoenas should not be honored. If you're a provider, you can say no, get a warrant, get a court order, or you file the medical record under seal with the judge, the court that issued the subpoena. So there is a provision that if the statement may be harmful to the patient or to third parties. I have had that in the criminal context, and we've been able to work around it. But again, I'm an attorney getting the record, not an individual. And once the record's given it to me, nobody gets it from me, right? Mm-hmm. So families are in a difficult position. Loved ones, guardians, spouses are in a difficult position when they're trying to navigate these waters that are well intended to protect the patient, but certainly are handcuffs in certain instances for the families. One point that I think is important too, there is confusion about medical records that were received. Your primary care doctor, let's say, has your x-ray records from where you broke your foot, and he said go to the ER and see the orthopedist, and they do the x-ray, and they then send the x-ray from the hospital to your primary care doctor, and you go in and you want your medical records. And some primary care doctors will say they cannot release the x-ray records from another provider. This varies across states. States have different issues on redisclosure. What I do is always make sure my authorization says all records generated from your office and any records received in the course of treatment from other providers. And generally, I get it that way, and that's permissible. The authorization controls.
Okay. Now, a couple other, and then we'll move on. They said the relative talks about their family members' violence, drug use, delusions. The patient might turn that against the parents if they see it. Is the idea around why not disclosing what families have supplied? So that was
Yes, and that is exactly right. And the doctor there, the provider, can say, I think this could lead to harm to the parent who's reporting. And that would be an instance in which you wouldn't. Remember, I said earlier, it can lead to harm to the patient or to a third party. And in that instance, it would be to a family member who has accurately tried to relate information. So let's go to the next slide.
okay. And let me know when you're ready for another one.
So HIPAA and behavioral health, okay? Providers, not just behavioral health providers, because we have a lot of primary care doctors who are primary care providers who are doing behavioral health now, prescribing and seeing patients, the integrated model, and so forth. So providers, not just behavioral health providers, may always share information with a personal representative. Now, that's a guardian in Arizona or someone with a valid power of attorney. And they can always decide when to share information in order to treat patients and prevent self-harm or harm to others. If the provider is talking to people with the goal of preventing self-harm or preventing harm to others, and that's a reasonable belief, then they may always share information. Now, they may also share information if the patient agrees or does not object, and the information is relevant to the family members, friends, caregivers' involvement with the patient's health or payment. So, examples. The provider can talk to the mother or the friend if they come to the appointment, or the patient says, I'm going to be depending on my friend Susie to bring me to my appointment. Would you let her know when the appointment is? Sure. So travel to appointments, to pick up medicines, to coordinate care, and in times of crisis, when the provider needs to communicate with a friend, a family member about potential harm to the patient or to other people, and even to third parties there, of course, under the issue of duty to warn. So there are not absolutes against when a family member, a provider can talk to a family member. A great example always that I have people call about, usually the patient when they're angry at whoever they took with them to their appointment. And so they bring somebody in the room and they're talking, and maybe they bring their boyfriend. Or in behavioral health, they take somebody to their appointment and they say, I want so-and-so to be I want so-and-so to be here with me. And then in 2 weeks, they're not so happy with so-and-so. And the patient says, well, my doctor shouldn't have talked about my depression with my boyfriend there. Well, no, you bring your boyfriend, you don't object, you have him in the room and you say, I want him to know, that's fine. And it does not have to be an authorization. Let me reiterate something, however. Provider practices may be more stringent than HIPAA. And if I'm on the other side of this presentation, and we do it all the time, or most of my clients, almost all of my clients have been entities, providers, I absolutely advise them, whip out an authorization form. It's half a page. It says, I authorize blank to discuss my care, treatment, and future needs with blank, dated this blank day of blank, and sign the name. If the patient won't sign the name, ask the third party to leave the room. It's an easy thing. I'll bring an example and put it up on the website. It ought to be in, and if with the days of electronic medical records, it's very nice because you just do the electronic signature on your little iPad. it's even easier than have to carry around. We used to make them hot pink pieces of paper, which was my, I guess, feminist statement or something. But my third-party authorizations for third-party participation and listening were hot pink. And the providers would carry them around in their little folders. And it's easy. So we have to see both sides of the equation here and balance it. Patients' families want information. Most providers want to give it, but we are a litigious society, and so everybody whines once the bloom is off the rose, so to speak, and they're not so happy with, Jimmy that they brought along to, or their best friend Becky, because she's now dating Jimmy, and they brought her along to their group or their therapy appointments.
So we have two more, Holly. One was just a comment that a commentary in Federal Register about professional journal where students were encouraged to what they would characterize as hide record information in psychotherapy notes. I meant to say students were encouraged to record practices that were known to be controversial treatment modalities.
Yeah, there are all those things about 50 ways to skin a cat, 50 ways to leave your lover, all those country music songs. If providers, students in various disciplines want to keep information from being readily findable and disclosable and disclosed, then that's what they will do. And they will probably have a career checkered by that sort of sloppiness and deception. But there are more ways than we can count to do that. And it's worse, not better, with electronic medical records. In the old day, when we got paper records, it's pretty easy to see if you're going along and you're looking at progress notes and you're looking at lab reports and you're looking at image radiology, and suddenly the progress notes don't match up with the lab reports, or the you could see things more easily when you're looking at paper records and you got good at looking at them, right? Mm-hmm. It's very difficult to know what tab on an EMR record information was hidden behind, and when the individual who produces the medical records, it's very easy for them not to click on those tabs. There is, if the cases are in litigation, but that is a very major issue in the electronic medical records produced by a major provider of healthcare to prisoners, because mysteriously there are all these records in tabs that just never got clicked on, and so the record never got produced. You don't know that, but you did with a paper record, and maybe there's some providers online. I'm sure Dr. Goldstein is I would say that the likelihood of Dr. Goldstein missing what's missing in a paper record that he's going through is very low. I would say that, notwithstanding the fact that he's incredibly bright and smart and attentive, it's very easy for anybody, including Dr. Goldstein, to miss it because he doesn't know the tabs that were in the EMR. So we end up hiring additional experts in cases who are specifically familiar with every kind of medical record, and they go looking for breadcrumbs to tell us that a tab didn't get clicked. It's frustrating. So if we look at this screen, I want to go down and look at the last one, because this is a bullet that we were talking about earlier. Because the providers may disclose in information if doing that is reasonably likely to lessen, not less the risk of harm, lessen the risk of harm, or the patient is presenting a serious and imminent threat to the safety, health or safety of the person or the public. Now, those ors, ands, are critical when we read this. So the threat has to be serious and imminent. It can't just be serious but vague, serious but may not happen in the next day or so. It must be serious and imminent. Now, this is a completely personal observation, but I have litigated failure to warn cases. I am litigating a couple of cases now where warning and taking other steps would have made a difference in what proved to be a horrendous crime sequence. From a provider standpoint and from our standpoint as family members and loved ones and patients, you pick your plaintiff, okay? So if you're a provider and you're weighing, is this a serious and imminent threat? I really feel like I need to tell this parent this, or I need to tell the spouse, or I need to tell a friend. Do you want the patient to be mad at you and maybe even file a HIPAA complaint because you told somebody something that you believed as a professional was necessary? Or do you want that patient to go out and maybe kill somebody or get killed, and then you get sued for not disclosing? So we pick our plaintiff. And in my view, those who are concerned about care, concerned about communicating, concerned about continuity and preventing or lessening the risk of harm, you err on the side of patient well-being and protecting that patient from something that may be much more damaging and harmful to the patient or others down the road. So next.
Okay, so Holly, we have two other questions.
Sure.
Before I ask a question, so basically they need to be, they need to see imminent threat and they must have a plan. So if they say, I want to burn a building down, do they have to say how they're going to do it? I want to hurt my girlfriend. Do they have to have a plan to do it, or is just stating the nature of intent enough?
HIPAA does not use the same language that we associate, although somewhat as a myth, with suicide ideation or threats of violence. There is no requirement in HIPAA that they articulate a plan. The language that's in the statute is just what I put on the screen. So it's communicating to the to others is reasonably likely to lessen the risk of harm, or the patient presents a serious and imminent threat to the health or safety of the person, of himself or the public. So that's it. Presentation, Scott, to 112 people.
Okay, now the two comments. One is my daughter's conservator, a county employee, got a court order saying that she has to countersign any HIPAA release my daughter signs. Have you heard of such a court order anywhere?
Well, I see court orders almost every day that I've never seen or heard of before. So, and I say that respectfully to judges who are on the here and in general. Judges try to fashion a relief based on facts that are presented to them, hopefully by both sides. Now, if the daughter has a conservator, that means that somebody has been appointed by a court because the daughter has been found to lack the ability, the capacity, we would say, to manage her affairs. So it's different than a guardian, but in terms of spending money, she may have the conservator may be the payee for any disability or Social Security benefits. So the fact that there is a conservator says the court has been involved and has made some fairly significant findings about why this individual needs to be protected by a third party, namely the conservator. So the judge has obviously been presented with a set of facts that led he or she to enter this order requiring the daughter to sign an authorization. Now, it's not clear, is this a healthcare authorization, an authorization for medical records, or is it an something else? Because the conservator generally, could have powers relating to healthcare, but it's generally, not always, but generally more of a financial standpoint. So maybe I need more information on that.
Okay.
And we can, I see that somebody's posted, there was a question that came up. The individual, apparently the court has ordered that the mother have no contact with the child, and I assume this is an adult child since it's a conservator. So it sounds like this is a pretty thorny, contentious situation. And again, the judge can issue an order appropriately tailored to the facts. Almost all those orders are you can challenge, but almost any court order. You have to have standing to do it, and you have to be prepared to lose that standing if facts change. But it's certainly generally in probate court, generally in any court, somebody who's an interested party can try to find a way to go in and persuade the judge to rule otherwise.
Okay.
Okay.
So we have quite a few. Do you want to move on or answer a few more?
Sure. Let's move on, and then we'll come back and we'll take some of these others. So HIPAA and behavioral health continue. One of the areas where we have seen a response in terms of guidance from the Department of Health and Human Services and focus on HIPAA is in the opioid epidemic. The federal regs permit disclosure of information without patient permission in certain circumstances. Now, it's pretty obvious here. The patient is incapacitated or unconscious, right? They can't give consent. They can't give permission. So you can disclose. I love these regulations. But to prevent a serious and imminent threat to the patient's health or safety. So a provider can talk to parents about history of drug use, abuse, lots of things, and share information with whomever in order to prevent serious and imminent threat to the patient's health and safety. If the patient, however, has decision-making capacity, then the provider must give them the opportunity to agree or object unless the provider decides that the patient is facing the serious and imminent threat to health or safety. And then you go back up to the prevent serious and imminent threat. So this is the way regulations are written. It's a bit circuitous, but the opioid epidemic, and I realize I misspelled, we have opioid. This epidemic has made us correctly, I think, reflect on and revise the way we interact with friends, family, third parties about someone's history, what they've been doing, what they were doing very recently, tonight, this afternoon, yesterday, before, and disclose information about their care and treatment. Subject always to the final point that if the patient regains capacity, then you've got to offer them the opportunity to agree or object to sharing that in any information with the family who doesn't fit those criteria we talked about earlier, meaning they're present and the provider reasonably believes that it was okay to share information with them because they're in the room, they're in the ED bay, they're in the emergency department cubicle area. Then they've got to offer the patient the opportunity to agree or to object. And this is, of course, has to be consistent with state law. This would be the case in Arizona. The majority of jurisdictions, my recollection is that the last 50 state survey I looked at, the majority of jurisdictions do permit disclosure to prevent serious and imminent threat to the patient's health or safety, and the opioid regs did not change that. Next. So Part 2, this is the descent into, I don't know whether it's the descent actually into purgatory or the descent all the way into hell for those of us who might have that theological background. Part 2 is, I think, one of the most difficult sets of regs to read in any of the federal code. I think that the bottom line here, and I quote Dr. Michael Franzak without his permission, but I'm going to do it anyway. He said, well, Holly, it's written to confuse people, and it certainly has met its goal. So, and that's true. What SAMHSA, the new rule, and it's very new, July, tried to modify the federal regs which govern disclosure of about 18 activities that have to do with care coordination and case management activities and non-Part 2 treatment provider records. So the clinic that's treating somebody under Part 2 for a substance use disorder, let's say, has in their gets records from other non-Part 2 providers. They also try to deal with incidental messaging. In the past, if you sent somebody a text about the patient and you did it inappropriately, the only solution was to give your phone to your provider to be destroyed. Well, that's kind of extreme, because you can sanitize the device and get rid of those messages. So what Part 2 these regs did was try to simplify what records are no longer covered by Part 2 if they weren't the Part 2 providers' records, to permit less egregious solutions than taking a person's cell phone, giving you the ability to consent to release of information to an entity, not to a specific person. So, holy cow, you can finally sign an authorization that says they can disclose my records to the Social Security Administration. And I don't have to say, Mary Jones, supervisor desk 4, Social Security Administration, Tucson. It's remarkable that it has to get to this detail. You can also, there are 18 specific activities that have to do with, as I said, care coordination and case management that finally they put in the text of the rule so people would stop fighting about whether they were covered or not, because they were only mentioned in the preamble. And the consent, they added patient consent not required for medical emergencies due to natural disasters. So things like Katrina and floods and fires and so forth that's remedied. And then research disclosures, and this really gets into the weeds. In our facility-based research, you can be participating as a HIPAA covered entity with non-covered entities and business associates who were not covered in your common rule, which refers to your ethics committees or your institutional review committees. And this is important for some patients. It has been particularly important for minority patients, for people of color, who found that their research, that information from their medical record was used without their knowledge and distributed to business associates and to folks who were working on research projects, but were not actually HIPAA-covered entities, but got their information from a HIPAA-covered entity. And then, of course, the one I like as a criminal lawyer from time to time is the court, the prosecutors, the FBI, the states, the counties, the police can have undercover agents or CIs involved in investigations involving Part 2 providers for 12 months or longer by court order. So before we get lots of questions, yes, there are undercover agents and paid confidential informants who, as a matter of their job, infiltrate drug treatment and various activities that are associated with drug treatment programs for the purpose of finding people to arrest. Remarkable, but 'tis there. Next. So there are 2 HIPAA forms that everybody who is interested in getting access to their own information, helping your friends or family, or have responsibility for somebody. These are the 2 forms that you need to know about right up front with every provider, and you need to stay on top of it. The first is, I think, a highly overlooked form, which is the Notice of Privacy Practices, or the NPP. Because the providers can have more stringent or different requirements, just not less stringent than HIPAA, it is important. They must give you an NPP, and they must give it to you on a particular schedule. When I had family members that I needed to be concerned about this, I just put on my calendar and ask for a new NPP or ask to sign one every year. If you don't do that, first of all, the provider has to do it, but more than that, you have a risk of just being confused and not understanding about a change in the NPP. Now, the NPP can also be used to, if you aren't aware of it, it can be used to exclude certain people from certain access to certain information or documents if the patient asks that that be done. The patient can always ask that somebody not have access to information or to their records, and providers must, under HIPAA, abide by that unless there's one of the emergency exceptions. But you would be clued into that if you looked at the NPP. Now the second one is the authorization form, which we talked about earlier, but there are 6 pieces of information that a valid HIPAA authorization form must provide. The specific information to be used or disclosed, all right? For some people, some providers will not accept a form that says all information contained in the medical record, and I don't blame them. I don't recommend those forms. I recommend providing lines to check and then some blank lines so you can put in other things. The identification of the person or the class of persons authorized to make the requested use or disclosure. So Holly Giesel, attorney. Susie Smith, sister of Jody Smith. The specific identification of who's going to get the information, and description of each purpose of the requested use or disclosure. So for me, I write legal services. Somebody else may write care coordination, help with care. It just has to have a description of the purpose. Has to have an expiration date or an expiration event, and then it has to have the signature of the individual and the date. Somebody just commented they always put advocacy as the purpose, and that's a legitimate purpose in my mind. If the provider says we need to know more, then write in something that says advocate for better continuity of care and better outcomes for my friend. That usually does it. You know, they're buzzwords. You want to say better outcomes, better compliance, better continuity of care. Just use all those the word soup, the word scramble that we have, and put that in there in a positive way, and you'll probably get it. It probably will be fine. Somebody wrote better outcome, recovery, compliance. Absolutely. That's terrific. Next. HIPAA and state law. So as I mentioned, HIPAA recognizes, uses the term personal representative. That's their That's their name for the person with decision making, and it recognizes it according to state law. So when you are a guardian and you go to a provider in Arizona and they say, we don't recognize authorizations by guardians, no, we won't give you any information. Just go print off 45 CFR 164.512G and say, yes, you do. You must. Second, there is a new case, as of January, and I'm sad about this case because I think it reversed an important part of HIPAA that really did promote continuity of care and access to records by third parties. And it is a classic example of how the industrialization of HIPAA by for-profit firms, specifically national medical records gathering firms, I believe is to the detriment of patient care. Federal law controls the charges for medical records under HIPAA. And previously, the patient rate, which is cheaper than a third-party rate for copies of medical records, had always applied to third parties that the patient who were producing medical records, like the medical record services and so forth. They got the same rate. Now, we won't get into all these complicated calculations. There are direct costs and indirect costs, and can you bill for retrieval? Can you bill for storage? But these huge medical records companies sued because it was costing them millions of dollars. And the district court for the District of Columbia, one of the most prestigious circuits in the country, and federal court, ruled that the patient rates no longer apply to copies that are obtained by third parties. And so I have recently seen a bill for medical records for a patient who was seeing that Cleveland clinic and was there off and on over the course of a year, and the bill for their medical records was $1,600. Previously, that bill would have been probably $200 to $300. So now the patient can get the records, but that is a cumbersome process. I think that this is one of the worst court decisions, and it really, unfortunately, HIPAA, they need to go back and rewrite it to right around this decision, but it's a very, very difficult, it's a very detrimental thing in my mind, because it makes third parties obtaining medical records through these third-party services prohibitively expensive for most people in the country.
So Holly, when it says HIPAA recognizes personal representative, we had an earlier question that said, what can you do when you have a durable and healthcare power of attorney and the clinic denies access to the records for an SMI family member, and they said family member is incarcerated?
Right. If you have a valid power of attorney, healthcare power of attorney, the clinic should accept it. Now, personal representative is defined not as a statute, it is the person with decision-making authority. If your power of attorney gives you that decision-making authority to request medical records and to obtain medical records so that you can work with your loved one, absolutely that clinic needs to recognize it. It's in how that power of attorney is written. We know that this happens all the time, but clinics in Arizona and across the country tell guardians they don't have the right to get a medical record. So it's not surprising that they tell somebody with a power of attorney that they do. Again, the power of attorney needs to be written in such a way that, and it needs to be in the statutory form, which you can get on the Attorney General's website in Arizona. I don't know about other states, or you can hire a competent attorney to do that power of attorney for you. And then when the clinic says, or the prison says, no, we won't give you that information, that attorney will call them up or send them an informative, not a nasty, an informative email, and hopefully they'll see the light of day.
So if the person's in jail, does it still apply? Like if you have guardianship or power of attorney, can you ask for information on?
Absolutely. Absolutely. And in Arizona, there is, if you go to the Department of Corrections website, there is a place to go to request medical records. It is, now it is Centurion, and previously it was Corizon, but you can Google that and you'll find, and they have a form that I think is pretty good, that I think Centurions is still up, that you can get and fill out, and you send it to your loved one in prison. These forms do not have to be notarized. By HIPAA, they don't have to be notarized, but certain entities will ask for a notarization. MCSO, Correctional Health Service, used to do that from time to time, and I could never figure out why, because sometimes they didn't, sometimes they did. But a medical records request, a HIPAA authorization form, the signature by the patient does not, under HIPAA, have to be notarized. It's a signature-only document.
What if the patient can't write? Do you have to have 2 witnesses?
Can't write their name?
Correct.
Well, if they can't write their name, and I'm not sure what 2 witnesses does, but I guess 2 is, but I've actually never had that. I've had HIPAA forms translated into a variety of languages, including Swahili. And at Valleywise, I will tell you, Valleywise has virtually all their tons of informed consent and other documents, and for a research study I'm familiar with there, they had it translated into, I don't know, 7, 8, 9 languages. So you can get those documents translated. If it is a question of somebody not being able to write their name, print their name, or sign their name, my concern would then immediately go to competency or capacity.
Okay.
I've seen lots of, I've seen on my consumer side of the practice, lots of folks who had a variety of competency issues. I've never had one who could not sign their name, but it certainly could exist. And I would, I'm not sure 2 witnesses does it, but I would have them sign with what they can, an X, and then have a witness or 2, and I'd be prepared to, if I got pushback, have each of those witnesses sign a declaration. Doesn't have to be notarized, it's a declaration, and it's admissible in any civil proceeding in state or federal court in Arizona. It's very simple. You say, I declare under perjury that the facts set forth below are true. And you say, I was the witness to this this authorization attached as Exhibit 1. My friend Joe Smith is not able to sign his name. I personally witnessed him signing the document on July 22nd, 2020. So
can anyone ever do a in-person or a virtual, be on Zoom and say, I'm giving my aunt the right to have my medical information? Can they do that on a call?
Well, now there are 2 things there. Yes, on information. The provider can say no, but HIPAA doesn't preclude that, okay? Because a policy with the provider's organization might preclude it. But I think that falls under the patient agrees, and I can talk to you. So your loved one, let's say your loved one is in, or your friend is in another city, he becomes very upset, gets bad news, breaks up with a boyfriend, fails a test, loses their job. goes into a crisis center, is getting some counseling, getting some stabilization, settling down, and then says, I want you to talk to my friend, or I want you to talk to my mom. And then you go and get on Zoom. I think the provider would be comfortable. Most providers would be comfortable having your friend say, yes, you can talk to my mom, and you're there, or my friend, my sister, and have that conversation. If you are asking for your medical records to be provided to that person, then you do need a HIPAA authorization. So there's a different issue when you're talking about information sharing versus release authorization to release records. And I saw a comment by we were talking about the other topic about someone who couldn't sign their name. Mm-hmm. Then I believe you can do, and I hadn't thought about, I typically think about competency and capacity issues more than I think about physical disability. And that's not because I'm ignoring it. It's just because that's not predominantly what my caseload is. So I have what I will acknowledge is a self-limited worldview in that regard. And I mean no disrespect. It's just the way my head works. So if you have someone who is unable physically to sign a document, then that to me speaks to the need for someone to do an attestation or a declaration that the person requested this be done. The comment was about a stroke, so I'm assuming there that we're really down in the nitty-gritty now. Can the person talk but not move? Can they not use their hand, but they're able to express what they want? Mm-hmm. I think you could then record the person maybe saying. I'd also go back and look at, and I haven't done this, so I'm not going to pretend to know the answer. I would hope that there is something in the ADA or somewhere in HIPAA that I've just not gone and dug down into to find out how you accommodate that. Remember, the key to any disability is you are required to make accommodations in most instances. So if there's a provider somewhere who won't accept either an attestation or a recorded statement or by a patient who can speak but can't write, that's a really foolish provider if the person asking for the information is doing it for purposes of helping in care, avoiding harm, so forth. But it also, it seems to me, raises the issue of surrogate decision-making for that individual and potentially considering things like a conservator or a guardian, so that then the person isn't put in a position of having their wishes frustrated because our system isn't able to modify that. And the comment I also saw was tardive dyskinesia, which is, of course, different than a stroke. That can be a side effect of a number of medications. So it's something that could be something to be dealt with, obviously. If they can make an X or a mark and have witnesses, that's the situation where my reference to the declaration by the witnesses would come in as sort of a belt and suspenders approach, so that if anybody questions it, we know what's going on.
Okay.
So next. So let's play 20 questions. These are true, false. And what we'll do is we'll go through them and answer them. And then what I will do, simply because I did not get around to it in time, I will print or I will publish an answer key, which gives you the actual reference to the CFR or the part in the HIPAA or one of the guidances from the Department of Health and Human Services. So you've got the context of why the answer was true or false. Okay, so let's go. We've got 5 per page. So HIPAA prevents providers from giving copies of my mental health records to anyone unless I agree and sign a HIPAA compliant information release form. True or false?
I'll unmute people. I would say true.
Well, it's false.
Oh, gosh.
Because there is no such thing as a HIPAA compliant information release form. HIPAA calls it an authorization form. And you need an authorization form. Now, actually, there also your guardian could get it, right? Because a guardian or a person under state law who is stands in your shoes can come in and get it, although you didn't agree and sign.
Okay.
So HIPAA lets my provider share information about me with anyone unless I sign a form entitled Authorization to Release Mental Health Information.
False.
That's right. That's false.
Oh, I feel so much better.
Yeah, we all have test anxiety, right?
Yeah.
They can, remember, there are situations in which they can share information with anyone, but those situations are the ones that are defined in situations in which they're sharing the information in order to prevent that serious and imminent harm. Okay, so these are not straightforward questions, and I wanted to use them to get into exceptions. So when you go back and look at the situations where providers can share information, not records, but information, there are emergency exceptions, unusual exceptions that might happen. HIPAA prevents providers from emailing, FaceTiming, or texting me.
False.
False.
That would be false.
That's right. And that's, I think if there are no good things from COVID, right? But maybe we can find silver linings. And one of those is that I think we went about 10 years ahead when we were faced with a true public health emergency, and we had to find new ways to deliver services. So Zooms, emailing, FaceTiming, and so on are issues. Now, providers, texting, FaceTiming, emailing, you've got to have sufficient protections there, or you get into this inadvertent breaches and so forth. But we can talk about that in another provider session if there are enough providers interested in having that. Here's the one that I like. My clinic violates HIPAA by making me print and sign my name on a sign-in sheet.
False.
False.
False. Having you sign in and put your name is not the problem. If they have you sign in and write, Susie Smith, hysterectomy, Susie Smith, lung cancer, they can't, anything that can link you with a diagnosis or a procedure or a reason for being there is a problem.
What about, okay, so Holly, what about if it's let's say a specialized clinic for HIV something, or something that's so targeted that if you're a patient there, you likely have the disease?
Right. The HIPAA, the guidance from HHS does not say that's prohibited. But again, if I am a clinic, if I'm advising that clinic, I would tell them to figure out another way to do it, or to take a fat black marker and mark it off once you sign in, and then they go and put you in the record as having signed in. Sign-in sheets, it's interesting. I'm not sure why they still exist in a lot of clinics, because there are easier ways to do it, but kiosks and so forth, but that takes some technology, and I get it. But in the broad sense, if I go to my clinic and I sign in, I put my name down, and I'm at an OBGYN. All right, well, I don't go to an OBGYN anymore, but I'm at an internal medicine clinic. There's nothing wrong with that. That's not a HIPAA violation. HIPAA prohibits my family or a friend from picking up my prescription at a pharmacy.
Oh,
Yeah, false. That's good continuity of care, right? To have people help you get to appointments, help you get your meds, help you be compliant. So false. All right, next. HIPAA does not permit my clinic to give or sell my personal health information to a third party for marketing purposes unless I sign a business associate agreement.
True.
False. You don't sign business associate agreements. Only the business associate signs those with the clinic. There are situations where HIPAA, where a provider can sell your quote unquote personal health information to third parties if they have a business associate agreement and if there are restrictions on how it happens. So that is false. HIPAA permits my clinic to refuse to treat me if I do not read and sign the clinic's HIPAA notice of privacy practices.
probably true.
False.
Oh,
They can't condition care on your being willing to agree to their privacy, to sign their privacy practices. They will make you think that. They will maybe intimidate you into signing. I think you want to get them and sign them, but you don't have to, or just get them and decide whether you want to. So they can't condition care on your agreeing to sign the NPP. I have a right under HIPAA to see all the information in my medical record.
false.
Correct. Subject to the limitations that we talked about earlier, in terms of information in psychotherapy notes and information that the provider may view should not be provided to you. Number 9, my clinic does not need my written consent to send my PHI to another provider, the REBA, or Access.
That may be a trick question.
True.
They probably don't need it if it's an emergency.
No, it's true.
That is true. They don't need your written consent to send your medical record, your PHI, to another provider for purposes of treatment. The REBA and Access, the REBA is a regional behavioral health authority, which contracts with all our SMI clinics here in Arizona, or Access, because those are regulatory agencies now, and they're doing regulation and quality of care and so forth. So they don't need your consent to do that. Now, that said, a number of healthcare systems intentionally create silos, and they can require a patient signature and then not get the signatures as a matter of policy and practice, so they don't share information which can then be publicly discovered through a public records request. So HIPAA is in place to help promote the regulations to make information sharing safe because of all the security protections, to protect privacy rights of individuals, to prevent information that could be highly stigmatizing from being inadvertently or intentionally disclosed. And it serves all these purposes, but it also is used as a classic handcuff to prevent information from being gathered and put in across silos and therefore easily obtainable. So if you, many systems that you come across will be so siloed that you spend half your time figuring out where to get all the records that you want. I'm not saying that's the case in Arizona. I see it more in prison health than in others, but it can be a problem. So Susie, number 10, a supervisor at my health plan, not my clinic, gave information about me to a mutual acquaintance, Libby, who gossiped about that information to people in the community. Both Sue and Joan violated HIPAA.
False.
False.
False. Who violated HIPAA?
Susie.
The supervisor.
HIPAA applies to health plans as well as providers. And Libby didn't because she's not a covered entity. She's just a gossip, right? Now, Libby, depending on the information and depending on whether it was true or false, might have some other issues, but Libby is just a gossip. But Susie can be in hot water, and I would expect an employer in that instance to terminate her. That would be the only safe thing to do. Okay, next, 11. Healthcare provider cannot give the media any information about me.
False. They can say we've provided care, right?
They can, yes, and they can provide a limited amount of information. They can't say, well, he had a heart attack and, so on. They can say is in stable condition following, and they can give a bit of information there. There's some pretty good scripts as to what the media can say and can't say. And you'll see it on the news every night when they say, officials at St. Bartholomew indicated that the shooter is, or that the patient is in stable condition. Some providers choose not to do that, choose not to confirm that somebody is a patient. They choose not to comment on any issues in health relative to their health. That is an example of going further than what HIPAA prohibits. It's a policy or a procedure, and it depends on the institution and the reasons for doing it.
Isn't it pretty common, though, if you're trying to find your loved one that may have gone from an urgent psychiatric to a hospital, and now and they won't tell you, even if you're guardian, if you start calling around, most of the time they won't tell you that they're there.
Right. That's when you're calling. This is the media is reporting on an auto accident, reporting on something, and they've gone to the provider, and 6 gunshot victims were from a mass shooting, and they're at Valley Wise or they're at some hospital, and they'll say, well, there are 3 survivors, 3 who didn't survive. Tied in, of course, there with law enforcement, but they are not prohibited from giving information about a situation. So
does this apply to psych hospitals too? If the media said the patient, the suspect,
it doesn't say except for licensed psychiatric facilities. Do I recommend that they do that to providers? No, but you can. So number 12, a TV reporter violated HIPAA by reporting I was hospitalized with life-threatening injuries after being shot in the chest by police. What if the reporter got the information directly from an EMT who took care of my son? EMT has to keep that to himself. He is a covered entity. He's a healthcare provider. A policeman who was there, who responded, law enforcement should not be commenting either. Although the policeman is not a covered entity. So the policeman can comment, but the EMT cannot, and police usually do not, which is a very wise practice. But again, we're trying to tease out here what's a HIPAA issue versus what is a policy or a procedure of another entity, even a government entity. My clinic violated HIPAA by calling me by name in the waiting room and making me print my name on a sign-in sheet in the waiting room.
False.
False, that's right. And it drives me crazy when I go to my provider because they stop calling me by name and they give me this long number, which I lose on a piece of paper, and then I never know when they've called me. The number's like 14 digits long. I mean, it's crazy. But So I think it's useless. Sometimes the old-fashioned way is better, especially if you just want to call somebody by the first name. That's what I typically will tell providers to do. Just call them by the first name. I can sue my psychiatrist and clinic for giving information about me to my mother and talking about my bipolar disorder in front of my friend who accompanied me to my appointment. Okay. True or false?
The person that went to the appointment, they can't sue because they allowed them in.
Right.
Talking to the guardian, their mother, or talking to their mother, it depends. Was it an emergency? Did they have, yeah, I think context.
Yep, context. And this is a question that if you got it on a college exam, you'd go challenge the question, right? As being unfair. Because the psychiatrist and the clinic, in a way, are giving your information about you to your mother if they're just listening to her describe your behavior the night before, or before you attempted suicide, right? Or before you ran away, or attacked your father. So by listening and acknowledging that you're a patient, they are in fact in a way giving information, but they are also not prohibited from listening. And there's an important Arizona law that was passed thanks to Representative Bartow, Senator Bartow, which makes it clear under Arizona law that listening and conferring is not prohibited under our medical records laws in Arizona, and it is that strengthens the interpretation of HIPAA, which does not prohibit in emergencies from giving information or from listening and digesting that information. Okay, HIPAA requires my clinic to give me my medical information in a paper format if I request it.
False.
You are entitled to get your true or false?
False.
It narrowly the clinic is required to give it to you in the format that you requested. But they can charge you for that reasonable cost because not everybody has a computer. And I will tell you that I have come close to, well, I have screened, I've probably come close to pulling my hair out. I routinely get prisoner cases where prisoners aren't permitted to have computers for obvious reason. The jail doesn't, you don't have a computer in your cell, and inmates will ask for their medical records, and they will get a letter saying, as required by HIPAA, we are providing you this in an electronic format. Well, that's nonsense. You're entitled to get it in a format that you request, but you can be charged a reasonable amount for it.
So two comments. One, so when a celebrity goes into a psych or rehab, the information can be given to the media by the facility?
Your name cannot, the media, the facility cannot disclose your personal health information identifiably to the media. They can't say John Smith was admitted today in a psychotic break after meth use, right? They can't go out and say that. If in certain instances where your presence is known because the media has reported it, maybe you've given an authorization, or you're involved in an accident of some sort and you are referred to and they say, did the people who are here, who came to the emergency room through your in surgery, and they can give that limited information. Okay, but they can't go and announce your name and disclose your personal health information.
Okay, and a question
I'll
related to number 11.
I will post in the next week, I will post the specific language that talks about that in the guidance.
Okay. So they said, why did Dr. Chris say it was a HIPAA violation when asked about elderly and rest homes?
Because she's wrong. I mean, what personal health information are you disclosing when you say that there are elderly people in nursing homes who got pneumonia,
COVID.
got COVID, got chickenpox? That's not personal health. That's not one of the 18 elements of personal health information. That's a HIPAA handcuff. It's also a clever way to dodge a difficult question in a time when you're kind of overrun with a pandemic. And in her defense, maybe she wasn't really paying that close of attention because of the stress and everything that's going on right now.
Okay.
HIPAA does not permit my guardian to get my personal health information without a written release signed by me.
False.
False, absolutely. The guardian is you. And so that's all they need to be, is proof that they're the guardian. And most people should carry their guardianship papers around and deal with them, have them so they can back up that claim that they're the guardian. It's always good to have the proof. As a person living with mental illness, I can object to information about me being shared with anyone unless I have signed a release of information.
Depends. What if they have a guardian?
So that is true, although the guardian trumps that. And it's not just if you're living with mental illness. It's any time you go to a provider, you can say, I don't want any of this information provided to my spouse, my children, anybody. You can specify that. Now, there is a bit of a conflict. You'll think back to the HIV days when we were really
here.
An increase in HIV transmission, and physicians were confronted with say two partners who were in the same, or spouses who were in the practice. One spouse tests positive, confesses a high-risk activity, and the physician is faced with the question, do I share this with the other spouse, or with the partner, or with the girlfriend? And there is a body of law that emerged from that has to do with your duty to warn and very, very fact-specific information about when in those situations a physician can share information. I'm sure COVID will bring forth a lot of litigation about this because it too is obviously a communicable disease spread in different ways than HIV, obviously. But I think we'll have some clarification there as we do with these epidemics. We get clarity on these topics. HIPAA does not apply to information requested by my employer. True or false?
False.
False, absolutely. HIPAA is very specific that employers do not get information without the appropriate authorization form. And this is a situation where you want to be very clear about the information that can and cannot be disclosed, because of the risk that if the employer doesn't like seeing that maybe you were treated in a substance abuse program, or very important that you pay close attention to the limitations that can be included in any authorization because of potentially stigmatizing and damaging in terms of discrimination and even retaliation for certain health conditions by certain employers. HIPAA prevents a provider from listening to family members or friends about my condition.
False.
False, that's right. And I think this is probably we need a lot of keys to unlock those HIPAA handcuffs. I think this is probably the most important key. And I use it all the time. I've used it probably in the past 3 or 4 times in the past 2 weeks, where I have a client who may or may not be incarcerated, may or may not be in a crisis. And I talk to the screening agency, or I call and I manage to talk to the case manager or somebody in one of the clinics, and they immediately say, I can't talk to you because of HIPAA. And I say, yes, you can. I just want you to listen. I need to give you some information that I believe is important in your giving this person care and in understanding what's going on. I think it's important so that you don't have them leave or go into a lower level of care where they are not going to be safe and others may not be safe. And I say, just listen, take notes, listen. If you don't choose to write it down or you don't choose to pass it on, that's up to you. But I want you to have the opportunity to know what I know and to take it into consideration when you're trying to give the best care that I know your clinic wants to give. I've never had anybody turn me down. They all listen. Now, they may be listening and watching, you know, something, cartoons on TV, but they at least listen. And I know that I've done what I can to try and get better care, appropriate care for the individual. Number 20, law enforcement can get my healthcare information by asking my provider. True or false?
Probably depends. If you're in a hostage situation and they're wondering what's going on, and they look up that you've recently been released from a hospital, or I would think it depends.
Well, in that situation, I think that would be the pick your plaintiff, right? You do what's right in that extraordinary situation. The answer is they cannot get it false. Law enforcement, although I've had this happen in a small town in Arizona, they waltzed into this little clinic and said, hey, this guy committed a blah, blah, blah down the road. Yesterday we got him, but we need to get his records because we think he's got some mental problems and we want to really not go too hard on him. And they just went over and copied all the records and gave it to him. Trying to do the right thing, but did the wrong thing. They cannot. A law enforcement officer who wants healthcare information can get it by, sometimes they'll go get a subpoena in a criminal case or a civil case. Not sufficient in Arizona law and not sufficient under HIPAA. A subpoena is filled out not by a court. It's not a court order. In Arizona, attorneys issue subpoenas. We issue them from our desktop. It's just a computer-generated document. So no for subpoenas. Yes, if it's a court order of a court of competent jurisdiction. I'm not going to, if a court in Nebraska sends a court order to Arizona for a client, for me to give up my records, or to, they're wanting your wife, your spouse, your family member, or your child's records. No, it has to be a court of competent jurisdiction. And there are procedures, if it's an out-of-state court, to get that court order in that state entered here. And there's a big process to go through. A warrant, yes, because your attorney is going to object to anything that was seized inappropriately. And a court order, yes, although if it's a client's records and it's a court order, and I almost always file those under seal and ask for an in-camera inspection in chambers. If there's something to be concerned about, in-camera means the judge looks at it. But there are steps that you go through that law enforcement will go through if they're doing it right, if they're not trying to get something in either a sloppy or a sneaky way.
We are at 6:58, so.
Okay, so we have 3 more. I will post the answers to these. We'll post an answer key, and I'm going to give you a little 3 or 4 sentence explanation with citations on each of those. Let's quickly go on. I did 20 questions, and then I thought, well, I really want to do 24. Okay, so some resources. I have a more expansive bibliography, but you can always check our website. Anybody who has questions about anything in mental illness should call or text Andy Arnowitz at COPA, because he is the best Encyclopedia Britannica of information. I get stuff from him every day. He's probably saved me $500 easily in CLE because he's so on top of all the literature. Let's keep going quickly. There are a couple more slides I want to highlight. Arizona, in my view, guys, is uniquely positioned to improve patient access to information and improve our quality of care. We don't have an unduly restrictive state medical law. Representative Bartow, Senator Bartow, succeeded in passing a concurrent resolution recognizing the rights of family members, caregivers, and guardians. First state nationally to have that kind of recognition, that resolution, and it was unanimously approved by the House and the Senate. We have a very strong sense of the legislature that it's important for patients, families, providers to work together for the best kind of care. I think it's a terrific and somewhat remarkable resolution. And we have SB 1442, which passed, which clarifies, and Jim McDougall worked on this, I believe, clarified that providers may receive, listen to information from family and friends. So we've got a great opportunity to really come together and creatively come up with some good guidance for providers who are struggling in this industrialized HIPAA environment to do all those compliance things they need to do with all the electronics and the security and so forth. So let's help get the privacy rule back to what it was intended to be, which is a way to protect personal privacy, but promote continuity of care all across the whole network of providers and facilities. So next one, let's play a joke. So it's a knock knock joke. Knock knock.
Who's there?
Right? HIPAA.
HIPAA who?
I can't tell. But now you can, because you can say, yes, you can, because I know the privacy rule. Next, check the ACME website, resources, and I'll throw up sample HIPAA forms that usually work for me, and hopefully that will help you. That's it for tonight. Any final questions?
Nothing coming through, just thank you. If everyone wants to unmute, we can say thank you, Holly.
Thank you, Holly. That was
Thank you,
great.
Holly.
Thank you.
Thank you so much.
Great. So much
And thanks,
information.
Lori.
Yes,
Thank you, Holly.
I'm traumatized for getting wrong answers, but I'm going to study.
Well, I will say
Those were
that
tricky questions. Come on.
had that been, I'm sure that if Professor Michael Schaefer and all those really do good tests, I'm sure that Mike Franzak is rolling his eyes. I intentionally wrote those to be confusing, but it's a way to sort of dig deeper into the nuances. And that's what HIPAA can be all about, right? At that level.
Okay. Thanks, everyone.
Thanks.
So,
Thank you, Lori. Thank you,
Thank you.
Holly.
okay, we'll see you. Our next one is medication, psychiatric medication, with
I can't
two
wait.
experts talking about the pros and cons, and also the trickiness of why are they choosing this? What is a gold standard? What are the long-term ramifications, and how do we better? I think sometimes people go in the hospital, they get put on a formula, and then they stay on that. I don't think, and we can ask. I'm pushing back saying, that dose forever, really? What is that balancing act? So I think it's going to be a good one, and that's going to be, I think it's August 19th.
Great.
Yes, August 19th, 5 o'clock.
Yeah. Thanks, everyone. Thank you, Holly. It was great.
Thank you.
I
Thank you,
learned.
Holly.
Thank you.
Thank you,
Thank
Holly.
you. Bye.
Bye.
Take care.
You too.